ahead.
It's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there is nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court, as the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted. The record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum. And that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raise concerning your right to assistance of counsel, the record before this court over the many days that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir, and this court need not address them further.